Hello, I'm Mitali Singh and I'm currently working as a legal intern at LEXIS and Company. Today in this video, I will be talking about capital punishment in India. So we'll start with what is capital punishment, then what is the position of capital punishment in India. So capital punishment is a state sanctioned killing of a person for a crime. Since the British era, punishment or death penalty has been a part of our judicial system. It is still in our legal system, but capital punishment is given in rarest of the rare cases in India. While 109 countries across the globe have abolished the practice of capital punishment in their countries, but still 55 countries still retain capital punishment. Few countries do not practice capital punishment, but they have provisions of capital punishment in their judicial framework. Countries like India, Pakistan, China, USA, Japan have retained capital punishment as punishment for certain crimes. If I talk about India, in India under CRPC, punishment for murder was capital punishment or death penalty. Even before the courts can decide the validity of the death penalty, the 35th Law Commission of India in the year 1967 in its report stated that death penalty should be retained as it acts as a deterrent and it creates fear among the criminals. If I talk about death penalty or the constitution validity of death penalty in India, then the constitution validity of death penalty in India has been challenged from time to time and from cases to cases. And after the reenactment of the CRPC in 1973, there have been certain changes in the concept of death penalty. Now, under the Act of 1898, a judge has to assign reasons for not imposing the death penalty, whereas under the Act of 1973, under Section 354(3), special reasons have to be given for awarding the death penalty, not life imprisonment. For the first time, the constitutional validity of capital punishment was challenged in the case of Jagmohan Singh versus the state of UP. This case was decided before the enactment of the CRPC 1973. It was stated in the said petition that the death penalty violates Article 14, 19 and 21 of the Indian Constitution. Supreme Court held that the choice of awarding a death penalty is done in accordance with procedure established by law, and the judge makes the choice between the death penalty and life imprisonment based on the nature of a crime, circumstances and facts brought on records during the trial of the case. So after this case, the judges, a 5-bench judge gave its judgment in this case and held that the capital punishment was not violative of Article 14, 19 and 21 of the Indian Constitution. After this case, the Code of Criminal Procedure was reenacted in the year 1973 and certain important changes were made in the procedure relating to the imposition of capital punishment. Again in Rajendra Prasad versus the state of Uttar Pradesh, Justice Krishna Iyer held that the capital punishment would not be justified unless it is shown that the criminal is dangerous to the society. Again, the judgment given in the Rajendra Prasad versus the state of Uttar Pradesh was overruled in the case of Bachchan Singh versus the state of Punjab, wherein the Supreme Court held that the imposition of the death penalty is an alternative punishment for murder and it does not violate any of the fundamental rights enshrined under the Constitution. It was in this case the doctrine of rarest of rare case was propounded, which states that the capital punishment can only be awarded in the rarest of the rarest case. It should be considered as an alternative of punishment for the murder. Certain conditions and guidelines were laid in the landmark case of Bachchan Singh versus state of Punjab, and those guidelines were: the death penalty should be awarded in the rarest of rare case only. Some of the rarest of rare cases include Section 121 of IPC and Section 302 of IPC. Second, judges should take into consideration aggravating and mitigating circumstances into consideration. Then third, nature and gravity of the crime, chances of reformation of a criminal should also be taken into consideration. Now, if I compare and contrast Article 21 of Indian Constitution with the death penalty, Then Article 21 states that no person shall be deprived of his or her life and liberty under any circumstances or except according to the procedures established by law. The procedure of law clearly states that death penalty is to be imposed under the rarest of rare case only and according to the procedure established by law. So herein, if a person is and the rarest of rare cases are like murder. So if a person is committing the offense of murder, which is a heinous crime, or killing or culpable homicide, it means killing of a person, then such person should be given death penalty, because that person has taken a life of another person. So he cannot take a defense of Article 21 of Indian Constitution, because the person himself has taken a life of another person. And even apart from this also, the honorable courts consider all the facts and circumstances before giving the death penalty to that person who has committed the offense. So it is not violative. Death penalty is not violative to Article 21 of the Indian Constitution. So a death penalty is not awarded arbitrarily. It is awarded after following due process of law, and convicted person has remedial measures available to him even after Supreme Court has upheld the death penalty. The convicted person has a mercy petition to the President and the Governor of the state. Even after dismissal of review petition, the convicted person can file a curative petition. Thank you. That's it for this video, and I will see you in my next video.